and personally make a citizen's arrest. Good evening and welcome once again to Fired Up. I'm your host for the show, Bob Irwin. We are coming to you live from the gun store here in Las Vegas. This program is all about guns, related politics, and self-defense. We are live on Fired Up, is on radio on KSHP 1400 AM, and simultaneously on YouTube. If you go to YouTube and punch on or type in Fired Up with Bob Irwin, you will see our shows every Thursday from 5 to 6 p.m. We are in process of possibly changing our broadcast time on the radio. So if you are driving home and suddenly can't find us, please give us a call at the gun store and we will correct you to the correct time that our show is appearing. They're moving around a little bit because of interference from sports and hockey games and things. So the YouTube will be there. We control when that's up. Unfortunately, with the radio, we can't control. We get preempted for things once in a while. So anyway, tonight's guest is firearms defense attorney Donald Green. A little bit of background, and then we'll start into this.
All right.
Mess tonight.
Well, Bob, thank you again for having me on. I've been a lawyer in California and Nevada now 33 years, primarily based in Nevada. The substantial focus of our cases are criminal defense, firearms cases, and a little bit of business litigation. But most recently, we've been dedicating a lot of our time to firearms-related issues, mostly because of the new regulations which have been promulgated by the state of Nevada after the election and the Proposition 1, the new ATF forms 4473, some inconsistencies, and of course now we have the very serious problem with recreational marijuana being legal in the state of Nevada.
And those two issues are going to be the subject of this show. Normally at this point, we run through self-defense shooting cases or shooting cases that are of interest to people that own guns or have guns in their house and so forth, and what they did right, what they did wrong. If we run shorter than I think we're going to run, we have a few of those cases for tonight. We'll actually continue with that format next week. This show is dedicated to the two giant issues we have here in Nevada and a few other states. And herein lies the problem. We have a new background check law, and we have a new marijuana law. And we have received from the state, of course, a copy of their the petition thing that said the state of Nevada hereby decides to change statutes number so-and-so and so-and-so to this and this and this, providing for background check, who gets them and when, and so forth. It is very inconsistent within itself, saying what can be done and what can't be done. So we have the initiative that supposedly will become law, Exhibit A, as we say in court.
Yes.
And we have Exhibit B, the regulations as seen by ATF that just came in that tell us what we are supposed to do as dealers with this. And guess what? They say different things. That is the first, that background check thing is a humongous problem. And the marijuana follows into that to a large degree. We're going to talk, Donald Green and I, first on the marijuana issue and a little back and forth. I wish we had more answers. Right now, we have more questions than answers. I have to tell you, I have researched this quite a bit. So has Don. Our local district attorney, Mr. Wolfson, came by, and we personally discussed this and so forth. But anyway, here we are. The new 4473 form, the form you fill out when you buy a gun. We have new ones we're required to start using on the 16th of January. The law on the marijuana initiative, the state says takes effect January 1.
Yes.
So we have a 16-day period where we've got kind of both or neither law in effect. Anyway, when you go to buy a gun now, we received a copy of the new 4473 forms, and the one or two of the questions is reworded slightly, and the one that deals with marijuana now has a bold-faced statement in it, where it used to say, just say, are you an unlawful user or addicted to marijuana or any depressant stimulant, narcotic drug, or other controlled substance? Pretty clear question. And that's where we got the information that if you have a medical marijuana card, that you couldn't buy a gun because you are self-admitting to being a habitual user. Understand now, the state has made medical marijuana okay some time ago. It is about to make recreational marijuana okay. So the feds react by putting an additional line on the form you are going to be using after the 16th that says in bold type, warning, the use or possession of marijuana remains unlawful under federal law, regardless of whether it has been legalized or discriminated for medical or recreational purposes within the state where you reside. So, marijuana possession or use by federal law is a felony. The ATF is a federal agency, so marijuana is use of it, even recreationally where it's legal, is illegal under federal law. So, start wherever you would like, Mr. Green. What do we do with this?
All right. The Las Vegas Metro, as of November 16th, the Las Vegas Metropolitan Police Department, in their frequently asked questions section of their website, the question is, if I have a medical marijuana card, may I get a CCW, a concealed weapons permit? Answer from the Metro, no. The possession of a firearm by people who use marijuana is in violation of Title 18 of the United States Code, Section 922G per ATF. Now, I called the Metropolitan Police Department and got to speak to some people, but no one is committing because, number one, the law is not effective yet.
Right.
But I fully expect that the frequently asked questions section of the Las Vegas Metropolitan Police Department's website is going to have a point in their question. If I buy recreational marijuana, may I buy a firearm? The answer is going to remain no, because as you point out, under current federal law, even though we still have the Holder, that is Attorney General Holder memorandum from several years ago, directing his U.S. attorneys not to prosecute minor marijuana cases, it's only a directive not to prosecute and leave the prosecutions to the local law enforcement. It is still a federal felony, and it's made even clearer in the new ATF form 4473. It's in, I think it's like question 11, 12, or 13, and it's in bold lettering, and it makes it very clear, even if it's recreational use, against the law, not going to get a firearm. If it's medicinal use, it's against the law, and you're not going to get a firearm. So the answer is no, no, and no. And the Ninth Circuit, as you pointed out before we started on the air today, there's a published decision, Wilson versus Lynch. That is this woman, it doesn't say her first name, from Nevada versus Lynch, Loretta Lynch, published in September 2016, Ninth Circuit case, which governs, Western United States, California, Nevada, specifically states that a person with a medical marijuana card is not entitled to purchase a firearm. And this was a woman who went to purchase a firearm knowing that she had a medical marijuana card. Not only that, the person from whom she was going to purchase it, that is the federal firearms dealer, knew that she had a medical marijuana card, declined to sell the firearm to her, and she says, I'm going to sue. Lawsuit was filed, and she's lost.
Getting these cases are never simple, and why her case is not going anywhere, it's not going to the U.S. Supreme Court, is she claims, which we'll assume is true, that she doesn't actually use marijuana. She got the medical marijuana card, went down and applied for one and got one to support veterans who want to use marijuana for pain-killing purposes. And there are medical uses for marijuana, despite the fact the federal government says there aren't at the moment, that she didn't actually use marijuana. So if what she did was she lied on the federal form.
Could be. She could have been prosecuted for that.
If the form at that time said, are you a habitual user? It didn't ask her if she had a medical marijuana card. It asked if she's a habitual user. The truthful answer was no. So that's why people are waiting for the Wilson case to go to the Supreme Court. It didn't go in there. It's such an outlier of real life. There will be others, but it ain't going to be hers.
No. And she was arguing Second Amendment, not the Nevada Revised Statute or Nevada Constitution.
Yeah,
and I did note that in the decision.
When you make a decision to lie on the federal form, even if there's political protest purposes, it's still a crime. Don't be lying on the federal form. So now if you come in and you use marijuana, you have a legalized card, or you have a medical card, or you are using it because you have recreational marijuana, as of the first, and everybody can grow 6 plants if they live more than 6 miles from a dispensary or whatever. It's really goofy worded. So you got to decide, if they take a freeway, they can't buy the marijuana. If they go on the streets, then
where are you going to be 6 miles from any dealer in Nevada, in Las Vegas?
I have no idea, but they put all that crud in there, which makes it impossible to enforce. But the medical marijuana petition was written by a committee of people who none of them were gun dealers, and that's why it's causing all this problem. But the marijuana thing is tied into the background check things because of this. But so we are at the position now, Don, and I'm asking you hypotheticals as an attorney, but the law goes into effect on the 1st, according to the referendum.
That's correct.
So what about the people that are in the marijuana business but not using marijuana? The guy who doesn't use drugs, but he stands behind the counter of a medical marijuana shop and sells marijuana.
He cannot, by a literal reading of the federal statute and the Code of Federal Regulations, he cannot possess a firearm in that capacity.
Because he's a drug dealer.
Exactly.
Definition.
So not only a drug dealer, he's also in constructive possession of marijuana by virtue of selling it, distributing it. Even if he works in the back cleaning up the place, is he in constructive possession of marijuana? Theoretically. Or can he be charged with conspiracy to possess? Conspiracy to distribute marijuana? The answer is yes. He can't possess a firearm.
I have a particular question with a friend of mine, retired federal agent, who for some time was working as security for a medical marijuana provider, medical marijuana business that was starting up in Nevada. And so he's on their premise, working for them armed to prevent robberies. And, you know, it's a cash business, so they get robbed a lot.
Yes.
Because they can't bank, because the drugs, under federal regulations, the banks can't take their money because it's drug money, even though the drug is legal. I mean, this whole thing is absolutely nuts. But so would my security officer there be allowed to carry a gun to protect the money and or drugs from robbers at a medical marijuana supply place.
Medical marijuana or the private marijuana, the recreational marijuana, or both.
Either one. Is he allowed to have a gun to defend?
I would say no if
drugs?
he's employed. If he is employed by Mike's Marijuana Sales, they're here in Las Vegas, I would say no. But suppose that he's an independent contractor working for Mary's Security, and they have a contract. I would say that he can, because he's there, although his duties are being directed, he's not employed by the marijuana salesperson or the owner of the marijuana distributorship. So I would say that that's my argument to the court.
That sounds like a huge dollar defense of his arrest.
Well, that's why you and I are here, Bob. It raises the issue.
So
if it's legal under state law, I'm sorry.
Yeah, well, that's the whole problem. It's now it's going to be legal under state law, and it's going to remain illegal under federal law. And the feds have been pretty straightforward about that.
Yes.
They have no intention of changing this. And I don't think there's a taste in Congress to change it, because the bulk of them still believe it's a gateway drug.
Yes.
And don't want to legalize it. So I don't know how we get to this. It's almost like gaming law, where you know, in the old days when Nevada had gaming and California didn't, you would get arrested in your house having a poker game theoretically at 3 a.m. Now there's casinos, but of course, because gambling is illegal in California, or organized gambling anyway. I guess all gambling is illegal. I don't know, but we've got on this side of the line, it's okay to gamble. On the other side of the line, it isn't okay to gamble. So when people from California come to Nevada, they're allowed to gamble. When people from California come to Nevada, are they allowed to buy marijuana when we go to recreational use?
You can buy the marijuana, yes.
Well, they can buy it in California, so that's a bad example.
Right.
But
you can't buy the medical marijuana with the California license.
But you can buy recreational
marijuana. You will be able to buy recreational, and my support for that is an attorney general opinion. Now, here, let's get to
Well,
it.
I know this is the research guy.
There's an attorney general opinion from July 26, 2016, which was sent to the Nevada Department of Health and Human Services, which says, if a person brings in a California medical marijuana card, may that person purchase medical marijuana in Nevada? Answer is no. And that's a attorney general opinion. But I do expect that the converse will be true. If I am a resident of the state of California and I come to a hotel in Las Vegas and I go down the street and purchase medical marijuana with my California driver's license, may I purchase it? Answer, yes. Because remember, the medical marijuana card is specifically licensed by the state of Nevada, as are their providers. But a moment ago, Bob, you raised a really good point of why the ATF is probably not likely to change its position. We all deal with what's known as the open letter. That was a letter in 2011, which the ATF issued to all federal firearms licensees, which stated, in bottom line terms, marijuana equals no guns, period. That is still 6 years. That's now going to be 6 years old in a few weeks. And it's still the position of the Alcohol, Tobacco, and Firearms, and was part of the decision in the Wilson case you mentioned a few minutes ago, in which Wilson has now challenged the open letter as being a violation of the Administrative Procedures Act, but that got shot down.
We're not going to beat these cases on minutia of where the comma is and things like
Correct.
that. This affects so many people. Background checks. Now, this kind of, now we've given you a clear answer on the marijuana, right? If you do marijuana at all, no guns. The other question we left open, which isn't addressed in the law, are you an unlawful user or addicted to marijuana, antidepressant, or other controlled substance, is what it says on the form. It says are you an unlawful user or addicted to? Let's say you're not, but you are occasionally were an unlawful user of marijuana 10 years ago. Can you still answer that question? No? Or do you have to answer yes? Is there, when did,
If you answer yes, you're not going to get the firearm.
well, I know that, that's
If
not the
you answer,
question.
if you answer no, are you lying?
That's the question.
That's the question. So
Are you an unlawful user of marijuana?
So
Are you a convicted felon? Well, I was years ago. Are
you going to have to take a lawyer when you purchase a firearm? And the lawyer, even if when you take a lawyer, every time you fill out the 4473, the lawyer is going to tell you, well, maybe or maybe not.
Well, it's because we have no clear answers, and it's going to be a while before we have clear answers. That's my concern. If the guy says, you know what, I used to smoke marijuana, I quit last week, so I am not an unlawful user.
The only place that applies currently in Nevada is we do have a procedure under medical marijuana cards where you no longer want to have the medical marijuana card. There's a procedure whereby you send back the card. I suggest you do it by certified mail. You send back the card. There's a form where you fill it out. I, Mary Jones, am returning my medical marijuana card effective December 1st, 2016. Send it to up to Carson City where they issue these cards. And I would also send a courtesy copy to my provider, telling him, dear Dr. Jones, please be advised that I no longer need marijuana. I'm going to use other analgesics or other types of medication, otherwise legal medication to do that, but only as to medical marijuana. Well, I've had a case where the person said, I don't have it, but they have a medical marijuana card. And they were denied a firearm. But the issue now becomes, with the denial, we have to go all the way to the FBI in Clarksburg, West Virginia to get that straightened out. And that takes about 9 months.
My question was, if you quit using marijuana last week,
yes.
Can you put, now up until the first, everybody that used marijuana in Nevada was an unlawful user except those with cards. So now I'm taking one of those unlawful users who has now decided because of the law change, they're not going to do it anymore. So they come in and go, they ask us that question. Okay, I used to use it unlawfully, everybody knows it, all my friends smoked it. I've quit because I want to buy a gun and I no longer use it. Can I legally put no?
You know what? It's going to be a matter of conscience, because if what you say is true, the literal reading, that means that probably 75% of the adult population in California and 99% of the adult population in Hawaii can never own a firearm. If that's true.
Yeah, I understand that, but I'm asking you to answer a question that can't be answered. If a guy comes to our counter and says, I did it one time, but I don't use it anymore because I want to own guns, so I've stopped using it, so I'm going to put no on the form.
That is an excellent point. And if we look in another context, I'll take just a second to digress. If we look at another context, the Sixth Circuit recently addressed under that form, the 4473, the issue of mental incompetence from years and years ago. The Sixth Circuit in Michigan declared that provision under 18 USC 922G was unconstitutional as applied to Mr. Tyler, whose wife left him for another man years ago, and he put himself into a temporary facility years ago, and then when he gets a firearm 22 decades later, it comes up. Yeah. The Third Circuit is chipping away at the domestic violence portion of it, claiming that it's the wording of what happened in Pennsylvania and New Jersey. Both of those men, Binderup, Binderup, versus Lynch, that decision was like somewhere between August and October 2016. And now we've got a case out of Washington, D.C., Grace versus District of Columbia, in which a federal appointee, a Bush appointee, has declared that a portion of the federal firearms, a federal firearms as applied in Washington, D.C. is unconstitutional, and was argued in part by our Attorney General, Adam Laxalt, who filed an amicus brief with 22 other attorney generals in August. The hearings in Washington before the D.C. Circuit were in September, expecting a ruling any day. So there's chipping away. That's a good point that you make there, Bob, that what happens if I don't use it anymore? Do I go get a notarized statement? Is that going to be sufficient?
Well,
How do you do it?
when you put no on the form, it is, in fact, you're swearing before Almighty God in the ATF
Yes.
that what you're putting on the form is true.
And that's a federal felony to say no.
So if you actually no longer use it, so they catch you using it, they can go back to the form and say you lied on the form and charge you with that. But what I'm saying, when you have somebody, and there are people, I'm sure, commonly that use marijuana illegally, and now with all this crud to get a gun, they'd rather have a gun in their house to defend themselves than a joint in their house. So they quit smoking it.
Yes.
Because
How do you prove that?
that's the only way you can do it, because if you keep smoking it, your friends are going to rat you off. So, don't lie. So they quit using it. They're going to write on the form, no, I don't use it. There's no box to write anymore.
Right.
Either use it or you don't.
Stop using it, wait between 180 and 190 days, go down to a forensic toxicology center and do a hair follicle split of the hair on your head, for which THC can remain as a residue for about 180 to 190 days. Have that certified that it's not in there, and carry around those results wherever you go. That might be the result. But that's an excellent point, and that might be that person, Bob. You may have just set up a decent lawsuit for someone to challenge that.
You can't put on the form, I'm no longer convicted of domestic violence. I'm no longer convicted of robbing banks.
But those are forever.
Could put, I no longer use marijuana.
If you write that on the form, Bob, and you try to buy that firearm in multiple occasions, you'll be calling me collect.
Yeah, that's the inside joke about the calls we get from the jail. Will you accept a collect call from Nevada State Prison? Click. Okay. Now we've made medical marijuana use and buying guns crystal clear to everybody. If you use marijuana, you can't have it. There's going to be some gray areas, some lawsuits, and a lot of court challenges coming up. Background checks. We passed a petition in the last election. You may recall seeing it. It changes the law in Nevada and says that everybody is required to get a background check to buy a firearm. First, I have to say that this has no relation to gun crime at all. Zero. If you think of the rationality of this, where do they have the highest murder rate in the country? City of Chicago. Where do they have the strictest background checks? You can't get a carry permit without pulling teeth. You can't buy a gun from anywhere without 5,000 checks. And they still have all these murders that by firearms. Obviously, all the background checks do is disarm normal citizens and give us a lot of paperwork. They don't reduce crime. That being said, we have this petition that was put on that says everyone will get a background check. It exempts some interesting folks that we have as dealers, and I'm going to approach this from a dealer's perspective, and as Donald will approach it from a lawyer's perspective. We have no way to separate who's who. The statute says all kinds of things. Example. We're exempted from the background check when we transfer a gun to a law enforcement agency or a law enforcement officer who has a letter that says he's using it for duty use. Then he has to have the letter from his agency saying Officer Jones is allowed to buy a Glock 9mm because it changes whether we charge him excise tax and things like that. It's a little cheaper if you're a law enforcement transfer, which is fine. If it's not for duty use, Officer Jones comes in on his break, not on duty, driving his black and white, in his police uniform, and says, I want to buy that Glock. I want to keep it in my house. Do we background check him? Yes.
Of course, does he have a CCW? Separate and apart from his dealings as a police officer?
Well, most of them don't because they're not allowed to.
You see what I mean? Do you have a CCW, Officer Jones? No. Then we got to do a background check on you.
And that is a silly, stupid, idiotic bunch of paperwork to do background checks on uniformed officers driving their black and white patrol car. We are not stopping crime by running a background check with the costs and all the paperwork and whatever. It exempts them. It exempts any peace officer for duty use, though. It also exempts security guards entitled to carry a firearm under NAC 648-345. Now, that is a security officer that's been licensed by the state of Nevada. So, but if he wants to buy the gun, it says he can buy one because he's entitled to carry a firearm under the security officer statutes. But the metro officer in uniform standing next to him is not. The security officer gets one off duty without the background check. Or a member of the armed forces or another federal official. So if you're a member of the armed forces, you don't need a background check.
If it's in connection with official duty. If we read the way that the textual analysis. Now, if I am a member of the armed forces and I'm stationed out at Nellis, or I'm stationed out at the Air Force Base near Indian Springs, and although my driver's license says Wisconsin, I am still as a resident of the state of Nevada to purchase a firearm because the ATF regulations specifically allow me as a military, as a member of the armed forces, to claim my home of record as my home of record or where I am permanently stationed.
Well, that was the issue, permanent duty station.
Yes, sir.
We get lots of guys here on TDY.
Right.
They're temporarily assigned to red flag or here, there, and they don't have a permanent duty station. Them can't buy a gun. They have to buy it in their home state. But if they're here permanently, although their home is another state, well, there is no permanently. You've been in the service, you're not in permanently because
That's correct.
you move all the time. This is the one that I like best. One of the claims they make for background checks is it will reduce domestic violence. And then exempts sale or transfer of firearms between immediate family members, for which the purpose of this chapter means spouses and domestic partners or any of the following relations: grandchildren, aunts, uncles, nieces, and nephews. So we are claiming with the background checks that they will reduce domestic violence. And yet we're exempting spouses, domestic partners, relations by whole or half blood, adoption, step relations, my stepbrother, my parents, children, siblings, grandparents, aunts, uncles, and nephews and nieces. And I went down this road with Don before the show started, and there are a million types of domestic relationships. And what I normally throw at, and I threw it at Mr. Wolfson when he was here. You have a couple who are no longer married. They're separated, still legally married, but she's living in the garage on the same property. Is a separated wife a domestic partner or wife under this statute that the husband can give her a gun?
It depends. She's no longer a spouse because they're not married. But domestic partner, remember, now we got to go to the Secretary of State statute, which specifically defines domestic partners. Like, 2 women want to be domestic partners, 2 men want to be domestic partners. They go down to the Secretary of State and fill out a form. Or 2 people, man and woman, who are living together, can go fill out the form. So are you now a domestic partner? I would say no. If you apply, and remember, this paper that you have here was filed with the Nevada Secretary of State on page 1 at the top right.
Yeah.
So I would say that the answer is no. You couldn't transfer to your ex-wife because she is not specifically, or ex-husband, she's not specifically delineated in there. Neither is your brother-in-law. Neither is your sister-in-law, father-in-law, mother-in-law, or cousins.
And it says immediate family members, but then whole or half-blood, adoption, step relations, parents, children, grandparents. So if your grandfather wants to give his grandson a gun without a background check, he can do that. Doesn't say anything about living in the same household.
Right, it doesn't have to be in the same household.
So grandparents and parents and children, siblings, aunts and uncles, nieces and nephews are all exempt.
So long as you are otherwise able to possess the firearm, that's the exception.
If they are criminals, they can't have the gun, or they're prohibited for some other reason, like using marijuana from the other part of the show. How does this reduce, the claim is this reduces domestic violence, the background check law. If we exempt all these people from giving guns to each other because there are no background checks, then how do they get the data that reduces domestic violence if they're exempt?
I don't think they use the data. I think, again, you mentioned at the beginning of this show that what's discussed and fired up with Bob Irwin are firearms, self-defense issues, and politics. I think this was a clause which was put in for purely political reasons to sugarcoat the law and make it look like, look, it's not going to affect your family, but it has nothing to do, as you point out, with reducing the domestic violence or reducing, gun tragedies in the home. And Bob, as you point out now, these exemptions are specifically in this statute are the only exemptions, and the sale or transfer between these friends, between these people, specifically says when you do not need to have a background check. Yet if you look at the next section, which I think you're going to go through in a moment, when you're at the gun range with your buddies, I'll have a point to raise that when you get to it.
After we get through whether you're a family member or not that's exempt, and obviously they have to qualify, otherwise for a handgun they can't live in another state, that sort of thing. But of course, people that read this don't read every state statute, because they'll come in, they say all the time, well, I'm going to be exempt. I can buy a gun from my uncle who lives in Utah because we're exempt because it's family members. No, it's a handgun going interstate. There are other regulations. I got this one several times already in emails. An established shooting range authorized by the governing body of the jurisdiction in where such range is located. Now, that's pretty easy in Clark County because we license pretty much shooting ranges everywhere in the county. The county shooting park has a range. There's lots of indoor ranges. The gun store is the best one, but there are others. For the rurals, this is a big problem because generally in the outlying areas, being everything other than Clark County, people simply have an area outside of town, near the dump, whatever, where they go, shoot their guns, and everybody has for generations. But it is not an established shooting range authorized by the governing body of the jurisdiction where the range is located. They don't have one of those. Everybody just goes and shoots
They
at the
shoot
dump.
up, especially at Alamo.
And so they don't, either they're going to have to license the dump as a shooting range on the Elko City Council, wherever you happen to be, or transfer a firearm on that point. We go to the dump in Elko and go, you can try your pistol. Sure, here you go. Because it's not an authorized shooting range, this law doesn't apply. At a lawful organized competition involving use of a firearm, a lawful organized competition. For practicing a performance with an organized group, we're movies or whatever like that. And all of this has the last thing within the presence of the transferor. So I lend Don a gun because we're out hunting doves. He didn't bring his own shotgun. I loan him mine, and he walks out of sight. Is that a crime?
I would say yes. I am no longer in the presence of the transferor, Bob Irwin. Therefore, the park ranger is going to arrest both of us because we have not complied with the law, and both of us on a first offense are going to face a gross misdemeanor, up to a year in jail and a fine. And second, and all subsequent offenses are felonies.
But it's only category C.
It's still
Well, it's felony, so you can't have guns for the rest of your life. So
okay. But you see what I mean? We're both going to jail because we did not go to a federal firearms licensee in Elko and transfer the weapon and then go back hunting, or bring our own FFL with us, who has a computer link to the FBI background check system.
well, therein lies the other problem as a gun dealer. We are required under the federal guidelines, which they sent me. I alluded to that before with the, other than the marijuana stuff in here. As of the first, private transfers will be done by any willing FFL holder. We can charge a fee for that. And the idea is that Don and his, not his cousin, because they'd be exempt. No, cousins are.
Cousins are not
exempt.
cousins are not included.
Okay, so Don and his cousin come in, and Don wants to sell this rifle to a neighbor, not his cousin. So the federal guidelines say that when the gun comes in, we will put it in our A&D book, acquisition and disposition. The bound book, we are required to record all incoming guns and outgoing guns. So we do that. Then Don may wait while we're running the background check. He doesn't have to. The gun's in our possession. So he leaves. We now run the background check on the person receiving the gun and discover, worst case scenario, he's delayed. You may think being denied is the worst case scenario. It's not. The worst case is being delayed.
Yes.
He's delayed. And they say, okay, we need more time. We can't find the guy's background. Or Homeland Security steps in with their rule. He's not born in the United States. Therefore, Homeland wants 72 hours to check him on the no-fly list or no refugee list, whatever they do with it. Foreign-born resident, but not born here. We've got an extra 3-day wait at the moment from Homeland Security. Green card, still got a extra 3-day wait. So they didn't know that walking in the door. So now we got to hold the gun for 3 days. And the guy says, well, then I don't want it. So I'm leaving. So now we've got the gun. Don comes back in, or we call him and say it didn't go through. come back in. Do we have to do a background check to give him back to Don? Yes.
I would say yes, I agree
We
with
do.
you.
And so we're going to do a background check on him to get
Even
him
though
his
it's
own
my
gun,
firearm.
even though you already own it. And because you don't already own it, it is now owned by the dealer.
Technically in your possession, yes, you have taken possession of
It's
that,
in our book.
yes.
So now we can go down a road here where he comes back delayed or denied, and then we keep the gun. That's going to happen once in a while where both parties get delayed or both parties are denied. For a gun dealer, here's another problem, which I brought up to Metro with no response yet. We are logging the gun into our received book. It is ours. I didn't see anywhere in here where we run the gun to see if it's stolen or not. It isn't in here. So if we run the gun, I'll tell you how this works. Welcome to Nevada. We are required to use the LEADS program. LEADS is a private company in the Midwest, and we send them an email that says, we have just received from Don Green, address so-and-so, date of birth so-and-so, all this information. This gun, serial number, so-and-so, so-and-so. Now, if they run the gun, they don't do it right then. They do it when they get to it. It may be a day or two later. And they discover the gun is stolen. They send an email to LVMPD firearms detail, to firearms detail at LVMPD. Then firearms detail at LVMPD goes, oh my God, they got a gun in at the gun store, and they send their detectives over and verify the serial number, grab the gun, find Don, grab him for possession of a stolen firearm, except that doesn't happen. Firearms detail at LVMPD was disbanded. Those emails from leads go to no one. They have no detectives. They are not allowed to notify us that the gun is stolen because we're not a law enforcement agency. So theoretically, we hold the gun for a while. If we don't hear from them or hear from Metro, but we never hear from them. So we can't tell if the gun's stolen or not. Now, reality is every gun dealer in this town has somebody at the police department that they know well enough to call and go, on the sly, run this gun and see if it's hot. But that system's not going to work when 20 people a day are coming in going, I want to sell this gun to this guy or give it to him or whatever. So the background check system is going to fall apart right there because we're going to be dealing or selling stolen guns that we don't know are stolen. And I don't think ATF's going to be real happy with us if they catch a few of those and say, you've been licensed for 30 years and now you're selling stolen guns. What's wrong with you? What's wrong with us is we can't find out if they're stolen. Now, as I said, for all you gun thieves out there, we have ways to check. So, but when this thing happens, it's going to be mayhem. Now there's another thing not addressed here. Don sells the gun to Fred. We log it in, we log it back out, and give it to Fred with a background check. That is a taxable sale according to Nevada Department of Taxation. We must charge sales tax on that gun going back out over our counter because it is going from us, not from Don, from us to a new customer. It is a taxable sale. If he made that same sale to his friend living in the same apartment building, it's still taxable. People don't pay it because nobody knows the sale was made, but now we do because it's gone through a dealer. So it becomes a taxable sale. So now we are making a taxable sale. We want the guy to pay the sales tax. He goes, I ain't going to pay the sales tax. I'm going to go do this in a parking lot. Of course, people vote with their wallets. So just for that issue alone, the universal background check is going to drive all of these gun sales into the parking lot. It's not going to cause criminals not to get guns. The sales tax issue is going to loom large. Don Turner with the Nevada Firearms Coalition has been trying for months to get firearms detail that doesn't exist, and Department of Taxation, Department of Commerce, and all the people that are involved in gun transactions, and ATF, in the same room to go, we can't do what this says and also do what this says. We can't. So is the Department of Taxation going to back off and say we won't charge sales tax? Or the customer, what if he says, well, I'm not selling it to this guy, it's a gift. So now he's lying to avoid the sales tax, which is probably a crime. I don't know about sales tax lying. If we can't make the sale without charging tax. Now, the federal guideline says we do a background check through the NICS system, which is free. Nevada charges $25 for the background check. That's the state charge that you're paying when you buy a gun. For the background is a $25 fee to the state of Nevada. They get the sales tax, they get the fee for the background check. Their guidelines say we will contact NICS directly and avoid the background check fee. This from the state says we will run through the state repository to get the information. We cannot call the FBI and say, check this guy. Whoever wrote this thing doesn't realize we don't call NICS. In the states that they have this program, it's a computerized system that we get a computer with a locked-in line that only goes unhackable, goes to the FBI direct to their big computer. Yes. It's untouched by human hands. We type in the guy's name, we type in the guy's date of birth, we type in his place of birth, and if he's smart, we type in his social security number. That's optional. The computer goes bing, bang, no history on the guy, and we give him the gun. You can't call NICS and go, hi, this is Bob at the gun store. I want to run Don Green, date of birth, so-and-so. There's nobody to call. It's a computer. If the computer comes back to later tonight, then they tell a human. But we can't get there because we don't have the computer has to be secured so it can't be hacked. Or whoever the hacker is going to have a list of everybody who owns a gun in the whole country. So we can't go to NICS, dear guy who wrote this thing. It would have been really helpful if you had talked to a gun dealer somewhere before you wrote all this crap.
Yes.
Because we can't do it. So what happens on the 1st when the guy comes in and says, okay, we're here. We saw it in the paper. We got to do this background check transfer. What do we do? I don't know how we can do it. My plan at the moment is to not do them because we have to either violate state law or violate federal law. There was a piece in the RJ, the newspaper here, for those of you out of town, about this issue. Interviewed me and another gun dealer, and we took opposite positions. I took the position that if I have to violate state law or federal law, I'm going to violate the federal law because the federals have nicer jails, better food.
Yes.
He took the position that he's going to violate the state law and not the federal law because the jail's closer and they get less jail time. The point both of us were making in a tongue-in-cheek statement was we can't do this the way it's written. And yet this is in effect January 1.
That is the law. There's no changing it unless someone comes up with a plan to stop this or get an injunction. The problem is that the judge is going to ask the attorney, where is the injury to your client? Well, he has to pay sales tax. He has to pay the background check and, according to the statute, a reasonable fee charged by the gun dealer, which could be, according to the internet, could be anywhere from $25 to whatever he wants to charge.
And let me defend gun dealers for a minute for that
I'm on
statement
your side.
that they're going to charge to do the free background check, because we still have to dedicate an employee. Even if we have the NICS computer, we still have to fill out the form. We have to check the form. We have to make sure the guy put all the answers where they're supposed to be, and log the gun in and log the gun out. And my employees don't work for free. It's going to take 30 minutes or so to do this, and then maybe a lot longer when you get denials or delays, or the guy checks the wrong answer because he can't read. The forms are written in university language. Next time you fill out a 4473, read it. Half the words people that come in here don't understand what it means. And then the explanation of that question is written even in higher grade. I have had attorney after attorney read some of their explanations, and they look at it and go, I have no idea what that means.
Right. It's not clear at all.
And these are wordsmiths that do this, and they don't understand what it says. So they can't give you, as we've already experienced in tonight's show, they can't give you a yes or no answer without having a judge decide what it said. And that means somebody goes to court or goes to jail.
Right. And I think that on that point, we have to look at who's been recently losing Second Amendment cases in California. They're all people who are claiming that they're Second Amendment rights. But here, I've been advising people that we need to focus on the Nevada Constitution and the Nevada revised statutes, especially as to CCW holders. But I think that the excellent point that you make tonight is that the person to file a suit before January 1st would be the federal firearms licensee, the gun store, on the issue of whether or not this is a taxable event. That a judge can see that, and because, Your Honor, if I don't collect the tax, I'm going to get penalized. If I do collect the tax, then what do I do? Am I now the agent for all these private sales? And how do I collect it? How do I justify it? How does it go into my books? It is not clear, but it is an important point. And I think that the taxable sale issue is something that a state court judge, not a federal judge,
right,
a state court judge could hang his or her hat on and say that it is true, it creates a taxable event, it is not clear in the taxes, therefore this statute is unenforceable until further notice, issue the injunction. Yeah. And Bob Irwin wins.
Hopefully we do that. We're running out of time. Sorry about that. I knew this would get to this. We'll be back next week with Homicide Detective Phil Ramos, a very pro-gun retired Metro homicide detective, talking more about this. There's a lot of things we left out. We'll be touching on this on every show as we get decisions made. The issue on this, the big one, is going to be sales tax.
Yes.
It's going to be it. I can't see the state giving up their money. So look out. The private party transfers, when they get done, are going to be taxable, very likely, and the dealer's going to charge a fee for it. And you're going to be doing it in the parking lot because it's going to add $100 to the cost of the gun. Just what I think is going to happen anyway. We'll see if they can get this straightened out. Hopefully, it can be straightened out beforehand, as Don said. I can't see sales tax giving in without a judge's order. So it's going to, someone has to be harmed first, so we can't even start the case till January 1.
Or a declaratory relief by the federal firearms licensee, who is going to be forced to collect the sales tax. I think there's enough injury there of what I'm going to have to do on January 1st. There might be enough to get your foot in the door into the courthouse before that effective date.
I'll leave that to you. I can just see them from my perspective going, you haven't been harmed yet. Who are you suing? You know? And I'm not harmed anyway. It's the customer that's harmed.
Right.
So we're done. Thank you for listening. We'll be back next week with more.